My name is Brian Schuk. I'm an attorney in Delavan, that's in Walworth County, Wisconsin. My practice is, I would say, primarily landlord-tenant. I've been doing it for about 11 years. I represent both landlords and tenants and help them in these issues. The changes in the laws and how and what tenants' rights are, for the most part today, under both federal law for the foreclosure action and the state new omnibus bill. The omnibus bill that the legislature just signed took effect April 1st, took some of the administrative code rules, ATCP 134, and in essence codified them into statutory requirements. In doing so, they've modified some of the longstanding traditions of the rule, which prohibited the rule from applying to certain areas of residential tenancy, where landlords traditionally weren't expected to be landlords. It didn't have the real oomph that Section 100.20 of the Wisconsin statute created, and as a result creates more liability for landlords who didn't expect to have this liability. Most importantly is that the security deposit rules are broader and have differing times upon which the landlords have to return security deposits than they did under the original rule, so they need to keep track of that. Secondly, there are not just 7 deadly sins now under the rule, there are now under the statute 8 deadly sins, 8 rules, things that if you put in your lease will become void and unenforceable, which changes what we've commonly known as the barrel standard to consist of. And I would say those are the most important things, but really there's one that I should say is even more important. That is, the last section of the Act talked about how potentially the statutory violations under 704, these new sections, could be treated as an unfair trade practice under 100.20, which used to be only the rules, and now it's also the statute. So this is something to be very concerned about, and they should watch out for. Representing tenants, realistically, the tenants, again, that last section, now you have a statute you can rely upon. It used to be just the rule. So if you had a rule violation with a monetary loss, you got double damages. You got reasonable attorney fees. Now you may potentially have a statutory violation and a monetary loss, giving you rise to reasonable attorney fees and double damages. And this is a huge thing. This gives rise to potentially a lot more claims and a lot more protections from the for the tenants. That's probably the biggest thing that came about with this change, and whether it was intended or not is unknown.